Thank you, Mr. Chair, and thank you, National Chief, and the other witnesses today. We do appreciate your time and your contribution to this process. I want to follow up a little bit on what my colleague, Mr. Schmale, did in his first round of questioning, and then move on to a couple other things if I can squeeze the time in. Minister Lametti on Bill C-15 specifically said that if passed, this bill will not change Canada's existing duty to consult with Indigenous peoples or the other consultation and participation requirements under other legislation, such as the new Impact Assessment Act. I know you've responded to the question of veto, and you've responded to some of those matters to my colleague. Do you agree with this statement by Minister Lametti? Does the implementation of Bill C-15 change the government's decision-making ability in the context of projects?
I'll make some quick comments, and I'll ask my lawyer friends as well to make some comments. And thank you for that question, Mr. Riddell, and good morning to you. And I would say, and I was going to make my comments earlier on as well to Mr. Schmale's question about it. Federal government has jurisdiction, provincial governments have jurisdiction, but not to forget First Nations government as well. They have certain jurisdiction as well. So it should be a joint process, joint decision-making process, and our full involvement. That's what has to happen going forward. We've always been excluded. And that's the issue and concern that things need to be addressed going forward, that unilateral decisions cannot be made. There's got to be a cooperative, collaborative, working together approach, and that the rights and title holders have to be involved going forward. So that's my quick comment to that. Don't forget the other jurisdiction as well. Mary Ellen, maybe you can comment from the legal perspective. Willie?
Yes, I can. And I don't know the exact context in which the Attorney General made the comments, but I can certainly say that consent is something that is part of the law of Canada now. In terms of the government's obligation to create a proper framework for consultation, engagement, and consent, that has been determined by the Supreme Court of Canada on multiple occasions. But it's important, again, to emphasize that consent and veto are not the same thing. And consent is not a veto over resource development. No rights are, of course, absolute, and government has government powers. We're acutely aware of that. One of the issues with this bill is to have operationalized that concept very early so that First Nations are engaged with as governments with the proper rights holders early in processes where there are developments, and that Indigenous people are not excluded from development. And in fact, if we look at some provinces like British Columbia, I think the highest number of new sort of mining permits have been given to companies working closely with First Nations, where free, prior, informed consent of the nations has guided that work. So I think the Attorney General's words about the existing framework, I'm not sure what they are. I do know Bill C-15 can add to and support that. But the legal framework is already...
Thank you. And I'm sorry, I hate to be rude, but they give me such limited time and I want to get to another question. So I appreciate that. One follow-up question. I've had a lot of people reach out to me, people that are concerned about linear projects, concerned about, the opportunity to develop linear projects. And many of these are Indigenous organizations that are looking to create prosperity for their communities and their members. And so my question a little bit is on a linear project. When I get you clarified the difference between veto and consent, but on a linear project, in your opinion, who is it that gets to give the consent or withhold the consent? Granted, not everybody's always going to agree. I totally understand that, but is there some clarity on your mind or clarity in your mind as to who gets to provide that consent or withhold that consent?
I'm certainly happy to respond to that, because one of the issues, as you well know, we're dealing with as we try and move away from this deeply colonial era of Canada's Indian Act is aided by the Declaration, is that the rights of Indigenous people and Indigenous governments can, the rights holders select the governments, and they must be able to do that. And we've been seeing that revitalization in British Columbia in particular, where hereditary leaders have been able to move forward and enter into agreements and so forth. And so the question of who is the government that you work with, it has to be the government supported by the Indigenous people, not the government picked in the colonial way. Now, we are in a transition process, The challenge we have is if you have a proponent of a project and that proponent has engaged one or two Indigenous people and says that is appropriate license from Indigenous people to go forward, you will have a problem. You must properly engage with the rights and title holders and their government. And this is where much of the work of industry and government has fallen down. And this is where this Declaration Act and the shifts that will bring greater clarity to that process. Because certainly, even just getting the support of an Indian Act band, as an example, may not deal with all of the rights and title holders in an area where there's traditional territory held by an Indigenous people. And the Declaration Act provides support here. The Declaration itself provides a new framework. It can help reduce some of that conflict, and as I say, operationalize these principles better, both for business and for government.
Thank you very much.